So welcome to our this week's question and answer session. Some very good questions. So I wanted to start with this one. It seems that the Supreme Court is defined by the Chief Justice, Warren Court, Roberts Court, etc. Does Chief what powers does the Chief Justice of the Supreme Court have? And then related to this, what has changed so dramatically in the last 100 years to make the Supreme Court so partisan? It seems that in today's world, almost everything has become so political, which is absolutely the case. And both of these are related to an extent. The Chief Justice does not have veto power or anything like that over the court. The Chief Justice is technically one of nine. His or eventually her vote, doesn't count any more or less than the other eight justices. But the Chief Justice does have a couple of powers. First, the Chief Justice has the authority to speak in the name of the court. We've seen this a couple times in the last few years. People might remember a couple of years ago when Roberts rebuked President Trump when Trump had criticized some federal judge, saying that the judge was a Democratic judge, and Roberts issued a statement on behalf of the court saying there were no Democratic judges, no Republican judges, they're simply judges. Secondly, and in some ways more importantly, the Chief Justice has the authority, if he or eventually she is in the majority, the authority to assign the opinion. And for a reason why that matters, if we think of a case from the past term, this case called Bostock, which dealt with whether Title VII protected gay, lesbian, or transgender workers from discrimination. And that vote was 6-3, saying that yes, it does. Roberts was in the majority, and so Roberts got to assign the opinion. One choice would have been to assign it to Ruth Bader Ginsburg, who would have doubtless written this very, very strong liberal opinion that likely would have pushed the law quite a bit to the left. Instead, what Roberts did was just assign it to Justice Gorsuch, who wrote a decision in favor of the gay and transgender workers, but who did so in a way that was quite narrow, that emphasized text, that emphasized a lot of conservative judicial thinking, and that will be the decision then that gets cited as precedent. So if you build that up, say 20 times a term, 25 times a term, the Chief Justice, 40 times a term, 60 times a term, it just depends on how much the Chief Justice is in the majority. The Chief Justice gets to assign opinions, and because the Supreme Court makes opinions on the basis of precedent, that's a very significant institutional power. That said, simply calling it, say, the Roberts Court doesn't necessarily make it the Roberts Court, and you can see it from this chart, which the New York Times compiled when Justice Kennedy retired in 2018. You'll note that of the justices, Kennedy vote when it was a close vote, 5-4. Kennedy was in the majority far more so than any other justice in the last 30 years. Gorsuch, you can see, is here above him, but Gorsuch had only been on the term court for 1 year by that point, so he was an anomaly. And then you can see all of these close votes down here at the bottom: abortion rights, same-sex marriage, the travel ban, Citizens United, Shelby County Voting Rights Act. Kennedy is always in the majority, sometimes with the 4 liberals, sometimes with the 4 conservatives. So you can make an argument that the Supreme Court between 2006, when Justice O'Connor retired, and 2018 really was the Kennedy court, not the Roberts court, because Kennedy was the one whose vote was almost always decisive on the big issues. The other thing that you can see from this chart, kind of answering the second question of how the court becomes so partisan, take a look at these breakdowns in critical vote after critical vote after critical vote from 2007 until 2018. You can extend this again to 2020. The 4 liberals on the court always vote the same way. The 3 more conservative justices, Alito, Gorsuch, and Thomas, Alito, Scalia, and Thomas before Scalia's death, almost always voted the same way. And Kennedy and Roberts, are more conservative than liberal, but would occasionally switch behind. That's really not the case. If you go back, 100 years, even if you go back 40 or 50 years, you would see some, less predictable conduct by the court. So, in some ways, the court, can sort of be seen as a super legislature almost. I mean, in a typical Supreme Court case, you basically know going in how Justice Alito is going to vote, how Justice Sotomayor is going to vote. And 1 out of 100 times you might be wrong in that prediction, but very, very rarely. That said, I mean, there are swing voters. Kennedy, now it's Justice Roberts, Justice Kagan occasionally makes votes that are surprising, but we have a much more partisan and polarized court, reflecting a much more partisan and polarized society than was the case in the past. Second question, what do you think attributed to Johnson's success in civil rights? Did he have more credibility as a Southerner? Was his interest in civil rights genuine, and was it effective? And then this question on Governor Barnett and Kennedy, and what would have happened if Barnett had basically gone along with Kennedy. So let's answer the second question first. Mississippi in the 1960s had a one-term rule for governor, so Barnett could not run for re-election. But if Barnett had sided with Kennedy, it's entirely possible, given Mississippi politics in the mid-1960s, that he would have been impeached by the state legislature and removed as governor. More important, the pattern as Mississippi governor is that once you were elected governor, then you could serve on corporate boards in the state. Maybe you'd be appointed president of one of the state universities. If Barnett had sided with Kennedy over Mississippi segregationists, that financial path would have been foreclosed to him. So he, there's no indication ideologically that he disagreed with the segregationist cause. But even if he had been inclined to do so, there were these kind of personal pressures against him not to go along. In terms of LBJ, the first question, yes, he had more credibility as a Southerner. In particular, it gave him an opening to Southern Democrats that they might be willing to listen to him, and even if they still resisted civil rights, not fight quite as hard than the case than was the case under Kennedy or under Eisenhower. Was his interest genuine? Undoubtedly. Johnson was not. He was in some ways a man of his time. You can see racist sentiments from Johnson from time to time throughout his career. But in terms of the personal and political and social equality of African Americans, Johnson is someone who took political risks throughout his career to achieve it, and devoted meaningful effort as president to ensure that Congress would pass the Civil Rights Act of 1964, pass the Voting Rights Act of 1965. And in this respect, I think he really is a good example of how people do matter. Kennedy and Johnson, in terms of their actual positions on civil rights, were very, very similar. But Johnson was personally committed to civil rights in a way I think that Kennedy was not. Kennedy was intellectually committed. Johnson was willing to take, significant risks and to devote significant political capital as president to the cause of civil rights, and it showed. I mean, basically all of the major civil rights legislation in American history for African Americans was either, at least in the 20th century, we have the Reconstruction stuff, was passed either when Johnson is president, or due to Johnson's activity as majority leader of the Senate, the Civil Rights Bills of 57 and 60. A couple set of questions on the gap between ideals and reality. First question is regard to the FISA court. How has its mission changed, if at all, from inception, and has its legality and secretive nature ever been challenged in court? And then the second question, you mentioned that Mapp versus Ohio has been watered down these days. Have there been any cases where an unwarranted collection of evidence has wrongfully hurt the accused? The answer to the second question first, there have been dozens of such cases. In effect, the way the law now is that unless the accused can prove that the officer was operating just completely in bad faith, the evidence, even if it was illegally obtained, is almost certainly going to be admitted. So, technically MAP remains on the books, but there are so many exceptions to it now that even if you have this unlawful seizure, if you're a criminal defendant, it's probably not going to help you in the end. It's and just in my opinion, it's a very problematic pattern that's been going on for 25 or 30 years, and in part reflects Supreme Court sensitivity to public opinion. I mean, they're not supposed to be sensitive to public opinion, but public opinion, at least until very recently, has tended to focus more on, you know, don't worry so much about civil liberties of accused parties. The focus is, we need as a society to be tough on crime. With regards to the FISA court, the FISA court is approved, it's created in the 1970s, is a great example of, transparency and civil liberties. The idea here is that you have a system, intelligence, which basically had no legal oversight before the 1970s, and so you create a court that will ensure that the kind of intelligence abuses that are exposed in congressional investigations in the early 1970s, when it's revealed that the FBI was spying on Americans without justification, the CIA was doing all of this nasty stuff, that the court can check this. It has not worked out anywhere near what we had hoped. Some of you may have noticed this when it came out in March. Didn't get the attention I think that it deserved. It was a report from the Inspector General of the Justice Department, in large part because it was released a couple of weeks after the virus just went national, and so for understandable reasons, the virus was the top news story and not this. But what it discovered after a former Trump campaign aide, a guy named Carter Page. Page was under surveillance from the FBI. The FBI had obtained a FISA court warrant. Page claimed that it was improper. There was an Inspector General report and basically said, yes, it was improper, that the FBI at the very least misled the FISA court, and at worst simply lied to the FISA court about the nature of the evidence against Page. Defenders of the FBI in the aftermath of this basically were saying, well, that's probably an exceptional case. Page, sort of a weird issue. It's a Trump aide, blah, blah, blah. This Inspector General memorandum, which came out at the end of March of this year, suggested no, that's not the case. In fact, the FBI many times had engaged in kind of misleading behavior to the FISA court, so that in reality, the FISA court isn't much of a check at all. It basically is kind of is a rubber stamp. To the extent was it likely to be legally challenged, I think almost certainly not, for two reasons. The first is that the with regards to intelligence pre-FISA court, the argument was that people under intelligence surveillance weren't entitled to any rights at all. So it's not as if this was an expansion of rights rather than a restriction. Secondly, and this gets back to one of the questions that we started with about the powers of the Chief Justice, one of the other powers of the Chief Justice per statute is to appoint members of the FISA court. So first Justice Berger, then Rehnquist, and now Roberts gets to appoint all the people who are on this court. So it's very, very unlikely you would see the Supreme Court say, the Chief Justice has appointed these bad people, we're going to eliminate the FISA court. So it's pretty much here to stay. The hope here is that the embarrassment over the Page and then this much broader Inspector General's investigation will make FISA court judges much more skeptical about FBI and CIA requests for permission to engage in intelligence scrutiny of American citizens. But on that, your guess is as good as mine, and I suspect we will not be seeing that. Last question here. Working on passing an amendment to strip the Supreme Court from basically having power and influence. My question is, where would we be today if this was something that had happened? Why would Congress want to have so much power over the courts? And do you think there was a hidden agenda at the time? This relates to the Tuck bill. Remember this guy, William Tuck, very conservative Democratic congressman from Virginia, who Richard Nixon, by the way, considers as a Supreme Court nominee in the early 1970s. There was no hidden agenda with regards to Tuck. The open agenda was basically to take uh, certain kinds of cases outside of the jurisdiction of the Supreme Court. And one of the reasons why the Tuck bill so alarmed liberals in the 1960s relates to the first question of where would be today if this was something that had happened. The concern was that if there was a precedent that was established where the Supreme Court made a decision in an area, in this case, the decision regarded reapportionment, and Congress then passed a law as it has permission under the Constitution to say that this area of dispute is outside of the jurisdiction of the federal courts. The danger is that the next step would be Congress would pass a law saying that civil rights are outside of the jurisdiction of the federal courts. And this was the reason why the Tuck bill was seen as so threatening. So if this measure had passed, this approach, I think, would be far more common. So you could imagine, a Republican Congress saying we're going to exclude from the court's jurisdiction over, challenges to workers' right challenges to business interests or something, and you could imagine a Democratic Congress saying we're going to remove from the court jurisdiction over challenges to state gun control legislation or something like that. And so what you would get is this kind of tit for tat approach where successive Congresses would consistently remove material from the Supreme Court jurisdiction, which would not be a particularly promising precedent. So that's the questions for this week. Hope everyone is doing well, and I will see you all on Monday. Okay, bye-bye.